Counsel, how much time would you like for a rebuttal?
5 minutes will be just fine.
All right, counsel, proceed when you're ready.
Thank you, and may it please the court. Good afternoon, your honors. My name is Eric Cerise, and I represent Mr. Johnson Sylvains in this appeal. This court should reverse Mr. Johnson Sylvains' judgment and sentence for the reasons stated in our initial and reply briefs. Although for the purpose of oral argument today, I'd like to focus primarily on issue 1, as labeled in the briefs, which is whether the trial court erred in denying the appellant's motion for judgment of acquittal as it relates to count 1, which was the lewd or lascivious molestation charge. And to answer that question, the court must decide whether section 800.045 requires an actual touching to occur in order to sustain a conviction for lewd or lascivious molestation. And the answer to that question is yes. Now, of course,
Counsel, let's say that we accept your premise. Let's say we do that. What is the remedy? Do we go back to the trial court to determine whether an attempt occurred, much like was found in count 2, or what is your proposed remedy?
The remedy is for count 1 to be vacated, for this court to remand this case back to the trial court for further proceedings. Those proceedings would be a corrected score sheet, because the lewd and lascivious molestation charge was the primary offense on Mr. Sylvains' score sheet. And he would be entitled to a resentencing under only the convictions that would remain in place. I'm sure this panel is aware of the fact that we did not challenge count 3 of Mr. Sylvains' trial. That is the lewd or lascivious exhibition charge. We had no good faith basis to challenge that conviction because based on the evidence that the state presented, that count went to the jury, rightfully so. But our briefs challenged the lewd or lascivious molestation charge, which we think needs to be vacated. And we also challenged the attempted sexual battery conviction as well. But as I mentioned, I think the most important question in this case, and really the driving question in this case, is whether—
Counsel, you in looking at the language of the statute, you make you focus on the to so touch language, and if it's entice a person under age 16 to so touch. If entice in the statute was replaced with solicit, would you be making the same argument?
We would be. It's our position that all of the crimes under Chapter 800 require an actual sexual touching to occur. Now, I know that would change depending on what subsection that we are focusing on, but let's take the one at issue.
You're saying lewd and lascivious exhibition requires a touching?
Right. So I've overspoke in that sense. Exhibition would not, but any of the ones that—
Lewd and lascivious conduct.
Yes.
So why? Here's my points. I mean, some words inherently don't require completion of the act. If you solicit someone to do something and the crime is soliciting, they don't have to complete it. You just have to solicit them to do it.
Sure.
And so when it says solicit to so, if it says entice to so touch, question to me there is, I get the emphasis on so touch, but what does the word entice do? And the definition that you quote us in your brief for entice includes to solicit.
Right.
Which solicit kind of inherently involves, typically involves when an act's not completed. It's just the mere solicitation that can go on to be completed. But the prohibited act is completed when the solicitation occurs. So to me, it's not so much this to so touch, it's how does entice act upon the words to so touch. So I guess what I'm saying is how you tell us entice means solicit. That's in your brief.
I think a lot of those words that are used in Chapter 800 are interchangeable. And I think there's actually a few answers to your question, Your Honor, as to why even with the language solicits in L&L conduct or entices under subsection 5 still requires a touch to occur.
Why?
Is for a few reasons. First, I know this court is aware that when we're construing statutes, we have to construe them as a consistent whole to try to harmonize them, to try to have some symmetry, so that we're not rendering some portions obsolete or redundant. So when you look at the first portion of subsection 5 under the lewd or lascivious molestation statute, it says that a person who intentionally touches. So I think there's no question that under the first version of L&L molestation,
Entice to touch.
Sure, but it really would be inconsistent for the first portion of that crime to require an actual touching.
Why would it be
And for the second
inconsistent? The two portions use different words. We don't normally expect different words to have the same meaning. Normally, if you use one word, one set of words in one part of a statute and a different set of words in another part of the statute, you're trying to accomplish something different with the different words, not the same thing with different words.
Sure, that's fair. But I think another way to resolve this issue is by looking to the attempt statute itself, 777.04. It's got a really important sentence in the first subsection. So 777.04 says in subsection 1 that criminal attempt includes the act of an adult who, with the intent to commit an offense prohibited by law, allures, seduces, coaxes, or induces a child under the age of 12 to engage in an offense prohibited by law. What the legislature is telling us in this statute is that those particular crimes are attempt. They're separate from the substantive crime of, let's say, lewd and lascivious molestation. What that tells us is that the crimes that are enumerated in section 800.045A contemplate an actual successful enticement or an actual successful sexual touching. Otherwise, this portion of section 777.04 would be rendered completely meaningless. And the remedy
Subsection 6, which refers explicitly to solicitation of a person under 16 to commit a lewd act. You think subsection 6A2 requires an actual touching?
we do. Now, I understand that that might be a bit inconsistent with what was raised in the initial and reply briefs. Initially, we had argued that this particular factual scenario is covered by L&L conduct, and so therefore you have to interpret molestation different than you would conduct. But in light of researching, frankly, for oral argument today and getting ready for this, we've discovered that 777.04 makes it clear that crimes that involve luring, seducing, and coaxing and inducing a child are attempt crimes under 777.04.
Counsel,
What
is
would
it
that
fair to
mean?
make a new argument, an oral argument, but the other side didn't get a chance to respond to
No,
the briefing?
I wouldn't necessarily say it's a new argument because the brief absolutely cites to the criminal attempt statute. I think really what this does is it clears up any ambiguity in terms of the specific language that the legislature has used to articulate.
You just told me it was inconsistent with what you argued in your briefs.
Well, I'm not necessarily, then I misspoke. I think this really just, again, it clears up the ambiguity with the word choice that the legislature has used. We have.
Counsel, then what do you think the word entice is doing in that statute? What's its function?
It's the method by which the perpetrator accomplishes the touching. Just as forces or entices is the method by which the perpetrator accomplishes the touching.
So are you abandoning your argument that the to so touch language, are you abandoning that argument?
Not at all, not at all.
Because it sounds like you're now going on some sort of an attempt argument, but that attempt wasn't charged in this case.
No, and we think that the facts at best fit an attempt, and that's all that was created here. And we actually filed some supplemental authority on this point.
Which leads to my first question as to the remedy. Could the court not have, pursuant to the Florida Rule of Criminal Procedure 3.620, could the court have found an attempt rather than allowing it to go through on the lewd and lascivious molestation?
No, Your Honor, because the jury wasn't instructed on that. Despite the fact, and this is what my supplemental authority shows, despite the fact that the standard jury instructions for L&L molestation, the crime at issue, includes as a permissive lesser included attempt. And so the facts of this case fit the attempt. They don't fit the completed crime, which is what the specific language of the statute requires. Another way to
the forces or entices, right? All right, go on.
Well, we're still all talking about the same thing, and another way to resolve what the legislature intended for this crime to cover is by looking to other statutes to see the language that was used in other statutes. And obviously, the court is aware of the statutory construction case law that says that when the legislature has included a provision in one statute but omitted it in an analogous statute, courts should not read into it. courts should not read it into the statute from which it has been excluded. That's the Messon case from the second DCA in 2019. Before I get into the specifics, I also want to point to the Gould case. It's the first DCA case 2022. That case says explicitly, the legislature has filled criminal statutes with examples that demonstrate it knows how to specify when it wants an attempt to be an offense in violation of a provision other than section 77704. A prime example of this is the sexual battery statute, which in a couple of spots criminalizes both sexual battery and an attempt that results in the injury to the sex organs. And then it goes on to say, there are many other examples. And there's actually a footnote in Gould, footnote 7, I urge the court to take a look at because it provides a laundry list of criminal statutes where the legislature explicitly included in the substantive statute attempt to commit X, Y, Z. That's not what we have here.
In reviewing 800.04, okay, the lewd and lascivious chapter.
Sure.
You have the lewd and lascivious molestation for which your client was convicted,
Yes.
which talks about enticing to so act, force or entice to so act. Okay, referring back to the first sentence of a touching.
Correct.
Then you have subsection 6 that talks about a person who, subsection A2, solicits a person under 16 years of age to commit a lewd or lascivious act. So is your argument that, frankly, there is a provision and a section of the statute that hits on the very issue that does not address touching, and that would be the lewd and lascivious conduct versus the molestation where it takes conduct and adds a touching element to it. Is that your argument?
Well, I'm not sure I fully understand your question, Judge.
Why would the legislature have two different provisions of the statute? One on molestation, one on conduct. Molestation, I believe your argument is here today, requires a touching. There wasn't a touching in this case. Therefore, there can't be a conviction for touching.
Yes.
For molestation. The state chose not to charge with conduct, which means to solicit a person under 16 to commit a lewd act. The solicitation itself to commit the lewd act is the crime under subsection 6 of 800.04. So it wasn't prosecuted under that.
Right. So on that point, I would disagree. I think that even under a plain language assessment of L&L conduct, a touching is still required for that crime to be committed.
So how is 5 different than 6 under, because you're now telling us you think they both require touching, which is different than what you said in your brief,
It's true.
right? So how is 5 distinct from 6 then?
Well, it in a variety of ways. 5 differentiates between body parts. 5 differentiates between age ranges and makes punishments different depending on.
They're both for under 16-year-olds.
Well, my understanding is that L&L molestation also goes lower than that. Yeah, I mean, under subsection B, Your Honor, it says an offender 18 years of age or older who commits an L&L molestation against a victim less than.
I know
12.
we're dealing with 5A. That's what your client was charged. on.
Sure. And I guess the main distinction there would be the difference in body parts. So I think that's
The difference in body parts is the difference between a sexual battery and a lewd and lascivious. That's where your difference in body parts come in your penetration versus touching. You're indicating your argument here today is that lewd and lascivious conduct requires physical contact.
We think so. We think under a fair reading of that statute, it does. If you look to the first portion of the L&L
Are you not
conduct.
undermining your own argument? I mean, he wasn't convicted of that.
No, he wasn't. He was convicted of L&L molestation, which we think equally requires an actual touching for the crime to be completed. And the best point for that is the legislature's use of attempt language in other statutes. So if you go back to that Gould case, they list a laundry list of criminal statutes that expressly include attempt to commit. And it's in the context of sexual activity crimes and crimes that involve enticement and luring. Section 784.011, sub 2A and B, a person 18 years of age or older who commits sexual battery upon or in an attempt to commit sexual battery injures the sexual organs of, so on and so forth. There's more. We put one in our brief. It's the use of a computer service to solicit sex acts from a child. 847.0135. This is in
So
subsections 3 and 4.
and that statute's use of solicit, it's just the soliciting. The act doesn't have to be completed, right?
Well, no, but my point is that the language of the statute says seduce, solicit, lure, or entice, or attempt to seduce, solicit, lure, or entice. The legislature specifically using that language in other criminal statutes, the same language that we see here in section 800-04-5, but they don't include the attempt to force or entice. As part of a statutory construction assessment, this court's supposed to look at those statutes and see that the legislature intended to omit one place where they have it in another.
But does that argument hold up if the state's argument is that just enticing would be the completed act? Then do we even need to get to the attempt? Doesn't that argument fall apart if the completed act is the enticement, which is what I think the state's arguing?
Well, sure, but I think our point is that it can't be under a fair reading of the language, which also includes the to so touch language. We have to consider this as a whole, and not only that, we have to harmonize the statutes so as to not render other criminal statutes superfluous or redundant. And if we did that, if we followed the state's interpretation, that would render what's in 77704 completely redundant.
Do you think the use of solicit in all of the sexual crime statutes always requires a touching then or a completion of whatever the act solicited is?
Well,
I think I like solicitation of prostitution, right? Somebody solicits a prostitute to engage in sex acts, but the sex acts don't occur. Are they not guilty of soliciting a prostitute?
well, no, I don't know the answer to that question, Judge. I think it's a fair point. But I think it has to be balanced with 7704, where they're telling us, the legislature is telling us that criminal attempt
Yeah,
includes.
but the point is, some acts on their own, the solicitation is itself an act. And
Sure.
so in some cases, the legislature chooses to criminalize an act. And in some cases, it chooses to separately criminalize just a solicitation of someone else to commit an act,
Sure.
right?
And I think under that specific example where we're talking about maybe soliciting prostitution, that would be able to be analyzed that way without cutting against what my argument is for 800-04. Under the plain language of 800-04, it requires an actual touching, and the forces or entices
You
is
keep
the
saying
method
that,
by
but it
which.
kind of just like, we don't get to the underlying why. What the plain language requires depends on what the word entice means,
Sure,
right? So to say the plain language requires it, we got to go deeper than that.
sure.
But the word entice is the key word here.
Yes, and
Is
I
entice akin to solicit, which I know obviously in many contexts is, and obviously you would use solicit often at times when you're requesting someone else to do something, right?
Right.
Like, it kind of makes sense to criminalize battery and attempted battery. It really doesn't make sense to criminalize making a request and attempting to make a request, right? Because there's not really, it's a much more difficult concept, attempting to make a request, because that's not really something you're likely to attempt and not complete. But there's a reason that you would, in
Sure.
the context of solicitation, not criminalize attempt, but criminalize, basically the solicitation is the attempt, right?
Sure.
It's a situation where the attempt stands on its own as a crime without the next crime being the same thing.
Sure, Judge, that makes sense to me.
The question is whether entice is the same.
Well, I think because the legislature has chosen in other criminal statutes to expressly say attempt to solicit or attempt to seduce, or even attempt to, sorry, entice.
In this statute, you have the legislature utilizing an 800.04. In one section, they say force or entice. In another section of the statute for another crime, they say solicit. Do you not believe that they're intending them to be different?
Hold on, and did you cite us? I'm sorry, I'm gonna give you.
No,
questions.
it's fine.
Did you cite us any statute where they said attempt to solicit?
I believe so.
one?
I'd have to double check the language, but
I know there was attempt and solicit, but was there a statute where it was attempt to solicit?
yes, yes, and it's in our brief. It's 847.0135 sub 3 and 4, and that relates to the traveling to meet a minor cases. and using a two-way-
8470135?
Yes, Your Honor.
right.
Sub 3 and sub 4.
All right, and I didn't mean to interrupt.
No, it's fine. And unfortunately, Judge, I seem to have forgotten.
Well, we're talking about the word entice and it's like it's being used interchangeably, entice and solicit. The legislature used two specific words, one in 800.04 sub 5,
Sure.
and the other in 800.04 sub 6. If the legislature intended them to mean the same, they could have very well used the same word, right? The dictionary has different definitions for entice and solicit, does it not?
It does, although they're often used interchangeably, but I understand from the legislative construction
Well,
standpoint that it's
entice
chosen.
seems to indicate more than the solicit. Solicit, you're asking, enticing, you're giving an increased.
Right,
ask,
there's-
And you're
right.
giving some sort of reward.
Right.
As I understand the language to be. So I guess the question is, why would, if you're saying that touching is required throughout that statute, and the legislature is using different language, and they didn't put the to-so touch in the conduct. You've lost me on this argument that you're making. Frankly, I've never heard this, that throughout that entire statute, touching is required.
No, and I definitely overspoke with that
Because-
right out of the gate because exhibition doesn't require touching, but I still believe that under the plain language of 800-06, or I'm sorry, 04 sub 6, which is L&L conduct, and 800-05, that based on a reading of that statute as a whole, it requires a completed act of a sexual.
All right, Counselor, your time has expired. I'm going to give you
I
3
see that,
minutes.
and I apologize for
because
going over time. Thank you,
We
Judge.
didn't exactly let you get through your presentation.
No, that's understandable.
I'll give opposing counsel the same extra time.
May it please,
Give
excuse
me
me,
1 second.
May it please
Fix the
support.
timer here. Hold
My
on.
name
One
is
moment.
Oh, I'm sorry.
All right, I think I've got it. All right, go, counsel.
May it please the court. My name is Stephen Putnam. I represent the state of Florida today. As to issue 1, under a de novo standard of review, the trial court properly denied appellant's motion for a judgment of acquittal. State contends that the plain language reading of the statute is logical and a legal interpretation of 800.04.
Counsel,
From-
if
yes.
entice does what you're suggesting in your answer brief that it does, that enticing, am I correct that you're saying the operative word would be entices, you don't have to have the touch? Number 1, is that true?
Yes.
Okay, next follow-up. How is that different than subsection 6A2? Why would they put both of those in there? If 2 is solicits a person under 16 years of age to commit a lewd and lascivious act, why would that be any different?
I'm sorry, can you repeat like what you're comparing? Are you
Sure,
comparing
the,
lewd and lascivious conduct? Or which one? I'm sorry.
Yeah, the conduct with which he is
So-
charged, so lewd and lascivious molestation under 5. My understanding is that you're saying just ask, I mean, let's just sub in words, right? Which I wouldn't want to do, but we're gonna do it. Entice, asks, trick someone into, right? I hesitate to say solicit because now I'm gonna go right to subsection 6, which says solicits a person to commit a lewd and lascivious act. What would be the difference in your mind between 5, lewd and lascivious molestation, and lewd and lascivious conduct?
So lewd and lascivious conduct, well, let me back up
Yeah.
a second. Lewd and lascivious conduct is actually touching, and there actually are attempts to commit that touching.
Oh, wait, hold
Further-
on.
oh, I'm
Lewd
sorry.
Lascivious molestation is, what's touching?
Lewd and
Conduct.
lascivious conduct,
Okay.
which is subsection 6.
But we're talking about A2.
Yeah, I'm talking about the
A2
second.
says
A
a
person,
person who solicits a person under 16 years of age to commit a lewd or lascivious act,
yes,
commits lewd or lascivious conduct. So one type of lewd or lascivious conduct is soliciting a person under 16 to commit lewd or lascivious conduct.
that's correct.
Okay, if subsection 5A also criminalizes requesting a person under 16 to commit one of those acts, how is 5A not completely duplicative of 6A2?
Because those are two different, so lewd and lascivious conduct can be, first of all, an innocent touching of any kind, but it's the intent. So like touching a foot or a knee, if there's a lewd and lascivious desire from the perpetrator, that's
Isn't
what
that
makes
true
it
of lewd and
conduct.
lascivious
First.
molestation also? I mean, they're
I'm sorry, Your Honor,
they're both saying lewd and lascivious.
but there's a difference. Lewd
Okay.
and lascivious molestation actually specifies touching certain parts of the body. Lewd and lascivious conduct is more general. So it could be used, for instance, touching feet I didn't cite that case, but there is a case like that. So that is basically the difference. The molestation is getting a sexual pleasure from touching certain parts of the body or having certain parts of your body touched versus conduct where it could be interpreted innocently. And I want to make just one more point about the difference also. That's a charging decision. So as a prosecutor, you get to decide what fits the facts better. And that's to help your case when you go to trial to meet those elements in a million different circumstances. So it would just depend on the facts. And in these set of facts, the prosecutor saw that the victim was told to get on her knees after being locked in a room or close the door and being private from the others and taking his pants down and exposing his penis.
So what do you think "to so touch" is doing in the sentence?
To
After
so
we
touch
said it's
is the
molestation.
goal. So the verb entice, which it is a verb, is, so just to go back to it, to make it make sense, to entice someone entice is a verb. The goal is to have them touch you. And in
What
some of the,
about
I'm
forces,
sorry, Your
though?
Honor.
I mean, if we're looking at this portion of the statute and it says forces or entices, it seems to me that forces to touch is not just. I mean, that would presume the completed act of the touch, because I
could
force you to
explain.
touch. Okay,
So let me just finish up with so in the lewd and lascivious molestation. So the first part of it talks about me as the defendant doing the touching. Now, the other section where it says or forces or entices is I'm getting the victim to actually touch me,
Does that
whether
help
through
them?
force, whether through enticement, but it's to touch my private organs or areas.
okay.
But within
But you
that
said,
statute itself.
no,
Oh,
go
I'm
ahead,
sorry.
Judge McCready. I
Within
think we're
that
gonna,
statute, they're talking, the first sentence is you utilize the example, you doing the touching being key.
Yes,
If you're just thinking about it and you don't touch,
Correct.
there is no crime
correct.
under this provision. The next sentence then says, or forces or entices to so touch. Again, it seems to be indicating the completion of the actual physical touching. And why in that statute is that not the same? Because otherwise you'd be in subsection 6.
I think when it comes to the whole statute in general, whenever I don't intend to understand why the legislature wrote the way they did,
That's why
but
you just use their words, right?
yes, and the plain reading of the statute is you're enticing someone to complete an act. Entice is a verb. Again, it is to have someone to solicit or to entice in some way. Like, and I tried to think of many different analogies of an attempted enticement, but you can't attempt an enticement. And I believe Your Honor made that point earlier. So does that answer your question? I'm sorry.
Well, I mean, when I look, under Merriam-Webster, entice.
Maybe just have some water real quick.
Wait, to attract artfully or adroitly or by arousing hope or desire. What action was done to entice rather than what solicit is, to approach someone with a request or a plea? Solicitation seems to be there under subsection 6. You just said it's a prosecutor's decision.
Mhm.
The record seemed to reflect that the probable cause for the arrest was for an exhibition. The prosecutor chose to take on the higher burden of something different.
Exactly.
But the touching seems to be very specific, needs to actually occur.
I think that, and how I read it, and again, just reading the statute on its face, it clearly says you either have to, I'm going to use myself as a defendant again, have to touch the person in those body parts, or B, I have to have them try, I need to attempt to try. And I think entice and attempt are interchangeably inside of that subsection, because the goal is to have them touch you.
But
That's the goal.
But there's statutes.
But I'm sorry, Your
There's
Honor.
statutes that could put the word attempt in there.
And again,
Right?
that's the other thing I'd like to say is, yeah, the legislature could have just cut it off. They didn't. Why did they need to put enticement or force? They could have just said touch, or they could have actually said to actually touch, or they could have put forced or enticed to so touch actually, but they didn't. They put it in because the way they, at least from my understanding, this is a part of a set of crimes that has a core of evil. I think I was reading in one case, and they wanted to look at all cases and all scenarios that could possibly be interpreted. And not all cases involve the defendant going and touching someone in an inappropriate area. There's cases where people invite children into vans, like the old stereotype that we've seen in movies with candy or puppies, what have you.
But what charge is that?
But see, that would be a different charge. That wouldn't be molestation.
Well, how is that different than what happened in this case when there's no completed act, right?
Mhm.
Why is it distinguishable?
It's distinguishable, A, because you are trying to entice a child or person to touch certain parts of your body that aren't exposed to the world.
So then in your mind, it's true that lewd and lascivious molestation could always be lewd and lascivious conduct, but under what, six, I had it before when I asked you, 6A2, but 6A2, lewd and lascivious conduct might not always be lewd and lascivious molestation.
Correct. Can I give a couple examples, if I may?
If you'd like.
Again, like lewd and lascivious conduct is an innocent touching that could be interpreted in indecent because of the intent of the person.
Isn't that sexual battery?
That's different. Sexual battery is having union with an orifice.
Why are there so many cases talking about double jeopardy in the context of sexual battery and lewd and lascivious molestation if lewd and lascivious molestation doesn't require a touch?
So sexual battery and lewd and lascivious molestation, part of lewd and lascivious molestation is that first part, the intentional touching. So that is analogous to sexual battery or attempted sexual battery. Basically, there is some contact between the victim and the defendant, where in that subsection, it says, or forces or entices to do so. That's different. And I'll be honest, I looked at every case I could. None of them are on point about enticement. They all the cases indicate that sexual battery or attempted sexual battery and lewd and lascivious molestation with the intent to commit that sexual battery are always charged together, or lewd and lascivious molestation with the touching, that part. But I was unable to find anything clearly that indicates that subsection of forces or entices or forces the touching. So I thought it would have been decided by now. This statute's been on the books for a very long time.
Do you have any case law that supports your your opposing counsel has raised several cases that I don't necessarily know hold expressly, right? I see it in there where they're referencing the touching, and I'll grant them that.
Yes.
But this explicit holding maybe that we would have to do if we reversed on this case. But what I want to ask you is, do you have anything that helps you in this regard? If they don't have the home run case, they have Kate, and maybe wants to now approach this on rebuttal, but if it just talks about the touching in the context of this statute, but there's no like home run holding, what do you have in the case law?
In preparing for this, so I'll be honest,
Yeah.
you do appellate law,
Okay.
but I've been a prosecutor for 10 years. I
Welcome.
did find not a new case, I'm sorry. I did find a case that alludes to it. And I didn't put that in my brief because I'm not gonna put a case in the brief that just simply alludes to facts. But if you would like me to supplement, I can, but in that case, briefly, the short version is it doesn't state any facts. It just says you either do it or you don't do it.
Do what? Touch?
Lewd and lascivious molestation. That's all it really.
Okay, so there's no case in Florida that you can identify that interprets the lascivious molestation in the manner in which you would like us to interpret it. Is that fair?
That is fair to say. And I would say in the general context of all cases that I've personally seen and or reviewed for this oral argument, I wasn't able to find anything specifically referring to an enticement and an attempt, because that just is not a thing. And you can attempt to do a lewd and lascivious molestation of the touching kind as specified in the first paragraph.
What about how entice is next to this word force? Because while maybe we could sit here and pontificate and say, well, entice could be attempt, maybe they mean that, but what are we to do with force? Because if force is next to entice, force, I would think sort of presupposes the completed act because you're forcing them to do the thing. If you haven't forced them to do the thing, you haven't completed the thing, don't we have to complete the thing with entice?
And force and entice both modify to so touch, right?
Right.
So force requires a completed act, that would indicate entice does too.
Yes. So I'm sorry, can you repeat that just briefly, just the point you wanted? I'm sorry.
I'm sorry.
That's okay. all right, I'm troubled by the fact that force and touch are right there. They're after the same disjunction.
Oh, I see what you're saying. Yeah.
So if you were to
Matter.
say, and Judge Mines is right, they're modifying the same to so touch. So we're going to now modify how we to so touch.
Yes.
We're gonna do it by forcing. Whereas entice could maybe have, I don't know, we're saying everyone's taking for granted that that could be attempt, right? Could force, I would think presupposes the completed act. You force
Yes,
them
you could-
to do. So why are those two things right next to each other and modifying the same prepositional phrase?
Because I can, and I'm going to use an example. So enticement is a positive way to get someone to do something. Force is, I have a gun. You're going to do X, Y, and Z to my body.
But two ways to accomplish what goal, right?
And the goal
Force and
is-
entice both modify to so touch,
Mhm.
and force really requires a completed act, right? To
No.
make sense.
No, you can force someone without touching them. Again, the analogy with the gun.
If you force someone to touch you.
Yeah.
I don't think you've successfully forced them to touch you unless they touch you.
No, you still have,
You've attempted.
but again, now you're using attempt and not, so that whole
Well, that's my
subsection.
point. They don't say attempt to force. They just say force.
Force. So you
So in
can,
the context of force someone to touch, that implies a completed touch, and force and entice both refer to so touch in this instance. So that if one refers to a completed act, it would make sense that the other one does.
I will disagree, respectfully disagree. I think that both of them are kind of inchoate crimes in regarding like you're attempting to, so again, I use the examples of force and entice. Forcing someone to do something to you, enticing someone to do something to you. You don't have to touch them to have that action. I'm going to tell your mom, if you don't touch my penis, that you skip school. That's a form of force.
Here's my point. If they don't actually complete, if the victim doesn't complete the touching, have you forced them?
Yes.
Touching?
I've forced,
I'll be honest, Council, that sounds ridiculous.
Didn't you just try to get them to force? Or
No,
didn't you try
that's,
to force them to touch you?
I think that's semantics a little because I am attempting.
That was semantics?
No, I mean, like the wording of force and entice are kind of interchangeable, just in regards to,
So that makes my point, counsel, about, well, if we take force and if, as Judge Mize put it, if you force someone to touch you, didn't you necessarily complete that act? You got them to touch you. Otherwise, you didn't actually force them to touch you. But if those are interchangeable, wouldn't enticing be doing, and I don't think they are interchangeable, but I think that they're modifying the same thing. I think that they are words that are next to each other. I'm to do something with that from a statutory construction standpoint.
can I respond? And
Yeah.
I still think that the first part talks about intentional touching. That's the person committing the act.
Right.
The second part simply says, I'm forcing or enticing the person to touch me. Does it have to be completed? I don't believe it has to be completed because you can force something like, for instance, again, the scenario, I'm going to tell your mom or I'm going to hold a gun to you. If you don't touch me, the person could run out, just like in this case.
And you think somebody would say, describing that situation, he forced her to touch him when the
Yes.
touching never occurred.
Because she ran out, she stopped it. So that would be
So
exactly
you
what
think when
happened
they
here.
describe that to somebody, they would say, he forced me to touch him. And the person would understand from that, that touching did not actually occur. That's your argument.
That is my
So you think
interpretation of the
that's- so you think
forcing.
the English language is used?
That is my interpretation.
And-
Because you can force someone without completion. You can
How?
force someone to possibly do something. Now, if they do it, they don't.
Well, distinguish that from attempt someone to force.
I'm sorry?
Distinguish what you just described. That's forcing, when the
Mhm.
forcing is not successfully completed and the touching doesn't occur. How would that be different than attempting to force somebody to do something?
But attempting, there is no, at least I'm unaware of any charge of attempted force.
I'm just talking about the use of language and how the word force is used, right? If I force, attempt to force someone to touch another person and I don't succeed, I think any normal person would say, he attempted to force him to do something. He didn't successfully force him to do something.
Again, I think it's the same as I stated that you can force someone to do something. If they do it, they do it. If they don't, they don't. Just like I can entice someone to do
So
something.
you force someone to do something, whether or not the thing ever occurs, you force them to do it.
Yes, because I force them to get on their knees, for instance, or I force them to.
Okay, so you force somebody to get on their knees, they say no and walk away, and they never get on their knees.
Yes, Your Honor.
Do you think people would describe, any user of the English language would describe that as you having forced them to get on their knees?
I believe so, at least I would. I mean, in the context of this whole statute, the way it's written, yes, because an intentional touching is at the beginning. And again, an attempted or enticement of that touch, or force or enticement of that touching is at the end to get them to touch you.
What are we to do with 77704 attempts, solicitation and conspiracy? What are we to do with that in light of your argument about what lewd and lascivious molestation means?
So when it comes to attempt, attempt is the completion of a crime, for instance, and it's an attempt to complete an action or complete some sort of criminal conduct. So like attempting lewd and lascivious conduct, for instance, would be a good example, I think. So an attempt to commit a lewd and lascivious conduct would be, for instance, going online. Police do these stings all the time and trying to get the person to come over to have that contact. Whether that contact is of a personal area or not, that's not really the case. My point is that there is a contact to be had and a final end goal in
Sure,
having that desire reached.
Isn't that the solicitation? You're saying it's attempt. The statute specifically calls that solicitation. That is lewd and lascivious conduct. It's not attempted lewd and lascivious. If you solicit, it in fact is the completed crime.
But there also is there are people charged with attempted lewd and lascivious conduct for that as well. So in like,
For attempting to solicit it,
yes.
so they didn't actually solicit it. They attempted to solicit.
Well, they attempted to have the conduct.
But don't you agree that the legislature has broken this statute down? Now, you used some phrase that you looked at in your research. They've broken this down by the various levels of activity with minors that they're trying to distinguish and say, we don't want you having any of these type of conduct with children, whether it be a battery, whether it be a molestation, whether it be an exhibition, or whether it be conduct.
Yes.
They've broken that down. They've included the language. How do you molest something without there being a touching of that thing, whether it be property in a criminal mischief type action or a child in an action such as this? So that's the language they use, is molestation under this section.
Yes, Your Honor. And I think that the legislature from the whole statute as a whole we're trying to find every single possibility to protect children in this country or in the state. So my point is, when it comes to that, they broke it down, but yes, they left that part of molestation because it's up to the state to decide how to charge it. If a man just walks around naked, for instance, and I believe actually there's a case cited where it refers to 800 and a man walks to the door naked and the Girl Scouts there or whatever's there. He comes back in the home and comes out naked again. He was charged under this subsection. So
Charged under molestation and affirmed on appeal.
let me pull it up, but I believe so.
That's
It was,
exhibition. And the question in that case is whether it was indecent exposure or lewd act.
I'm pulling it up. Let me just have a moment. Oh, here it is. Yeah, it just says under 0.04, 800.04, and it was from 84, so it really didn't specify all the different levels of types of molestation.
Did you stand by your argument in your initial brief that the appellant's argument as to issue 1 was not preserved?
Actually, we're going to move on from that, and the state will agree it was preserved.
Yeah, I mean, it seems to me when you wrote the initial brief that you ignored the renewed motion for acquittal, where they really specifically argue the specific argument on appeal, which I get. Everybody makes mistakes. It seems like you just, from the answer brief, it seems like you just completely missed it. But what I guess was when I see the reply brief pointing out that something in your answer brief was just patently false, I would expect maybe a response or an amendment or some kind of concession of the issue.
Again, whenever I didn't know that we could do that, to be honest, to reply to his reply brief.
Well, I wouldn't expect another brief, but I
Oh.
might expect some kind of notice of correction or
Well,
request to amend because
you're asking why that was in there. And I can explain briefly that usually, at least in my time in practice, some judges have said, hey, you've had one bite at the apple, you're done. You didn't present any new evidence after JOA, so you're done. But I agree and will concede that preservation has happened because usually JOA happens after the state closes their case. Then usually the state, the defense then presents some sort of evidence and renews because there's new evidence to consider. So I'm just explaining that in.
So you thought when you were writing your brief that a motion for judgment of acquittal made after the defense arrest without putting on evidence can't make new arguments?
Yeah, and I couldn't find any case law either way going back and forth. But my opinion, and again, I concede to it that it is preserved, but that it's getting a second bite at the apple. And I think that's something that trial judges, depending on the courtroom, determine.
Counsel, I know that you're out of time, but I don't want to let you leave without my understanding your argument perfectly about the word entice. Do you think that the act is completed when someone entices, or do you think entice encompasses attempt?
I think the enticement is the completion.
Okay.
So whenever you have done something to entice, for instance, in this case, expose yourself and have a child get on her knees, that's an enticement to commit an act on yourself. Like allude to lascivious molestation, which is touching those body parts as mentioned.
Any further questions?
No, thank you.
No.
Can I make just one more statement? And that's it, just that we rely on our brief, and thank you for your time.
Thank you. Thank you. All right, counsel, got 3 minutes.
May it please the court, 3 points on rebuttal. First, I want to address the discussion that this court had with opposing counsel about forces and entices and how the court's supposed to deal with that. In the Messon case, the court points to a statutory instruction canon called Nociter Associus. It's the associated words canon, which dictates that words grouped in a list should be given related meanings. When someone forces someone to eat a cookie, they bake the cookie. I think that entices should be given a related meaning, in that it has to have accomplished the touching. The second point on rebuttal is the state has argued that the legislature has not written anything in the laws that suggest you can attempt to entice. To the contrary, another statute that I'd like the court to be aware of, and this is cited in footnote 7 of the Gould case, is the 787.025. The statute's titled Luring or Enticing a Child. Subsection 2A says, a person 18 years of age or older who intentionally lures or entices or attempts to lure or entice a child under the age of 12 into a structure, dwelling, so forth and so on, has committed a first-degree felony. The legislature has chosen in other statutes to say attempt to entice, attempt to solicit. They chose specifically not to in section 804 sub 5. The last point I'd make is that in light of this discussion, it's our position that the plain language of subsection 800.045 requires an actual touching just under its plain words and meanings. But to the extent that there's any ambiguity, I'm sure this court is aware that the rule of lenity applies and that it should be construed in favor of the accused. And with that, we'd ask the court to reverse. The last point I'd like to make, being that I do have 1 minute left, is on the remedy judge. At page 192 and 193 of the transcript, the parties waived any lesser includeds, which means that the jury was only instructed on the completed crime of L&L molestation. The fact that the evidence does not support that, and the fact that there are no lessers that were actually instructed, that the jury was actually instructed on, under the Vroom case and under the Morris case that's cited in our briefs, the appropriate remedy is to vacate count 1 and remand with a corrected score sheet where count 1 is no longer at play. And Mr. Sylvain's be entitled to a resentencing with that corrected score sheet. So with that, we'd ask the court to reverse count 1 of Mr. Sylvain's convictions. We'd also ask the court to reverse count 2 under the arguments raised in our initial reply briefs. Thank you, Your Honors.
All right, the court will be in recess.
All right.